All right, everybody. YouTube is telling me that I'm live, so hopefully that is in fact the case. We did one of these as kind of a test pattern about a week ago to check out to make sure it makes sense. If any of you are listening or in chat, if you could confirm that this is actually coming through, I would appreciate it, since otherwise I don't know if there are any lights or anything that I can see that would confirm that this is actually working. But certainly YouTube thinks it's working, so that appears to be okay with me. So welcome to Virtual Legality Live, which is an idea I had that you probably saw kind of tested about a week ago that is about being able to respond to folks that talk in my comments to the various videos that I make, or otherwise hit me on Twitter or on social media to talk about what are very difficult and complex issues in the law or in business or in popular culture. And so I looked at those and I was responding to a lot of them, and I will continue to respond to a lot of them. But it occurred to me that one thing that we could definitely do is have a kind of live show. Right now, maybe once a week, we'll see. Obviously, as a father of young kids and with family obligations and legal obligations, I was working pretty much all last weekend doing law, which is, the unglamorous side of all this, but it is a lot of fun and I do enjoy it. You never know how this schedule is going to work, but right now we're going to see if this works. We're going to see how long of a video we wind up making here. It was very successful last week, much more successful than I thought it would be. And as a matter of fact, so successful, that there was chat happening too fast for me to respond to all at once. And one thing that I did want to say was thank you to a specific user, Dvorak Q, who did something called Super Chat, which was a button I hit some number of months ago before we were ever doing live anything. And they paid me $5. And I want to say I really appreciate that, because we like doing these. We like doing these videos. We like talking about these things. But in all honesty, there is not even remotely any argument that this is a more efficient use of my billable time than going and billing clients and doing my day job. But I don't want to stop doing this. I enjoy it. I enjoy having these conversations with you all, and hopefully illuminating a few of the kind of wrinkles and weird things that happen in business and the law throughout all of these videos and throughout our experience with pop culture. But I did want to say thank you to Dvorak Q for that super chat. That was very nice of that user on our first live program on January 12th. So I did want to say that I appreciated that. With that said, now here's Virtual Legality Live. We're going to talk a little bit about the videos that we did this week. So if you're in chat, if you have any questions, if you have any comments on anything that you don't think I covered in the video properly, if you want to disagree with me, I'm going to try to respond to chat, the people that are actually here, as much as possible. And then I'm also going to try to look at some of the comments that are in there that I talked about with people. But whenever we're talking about legal issues, when we're talking about business issues of some level of complexity, it's very easy to only put two sentences down and miss all of the various levels of nuance that are related to the question at hand. So hopefully I can be a touch more responsive to people that are chatting here. And I see this, and that actually raises another point that I wanted to add. When the chat comes in, it comes in very fast. And that was my first live show last week. One thing I'd like to highlight is if you do use the @Hoeg Law, or if you use the name Hoeg Law, it kind of pops out for me a little bit. Don't abuse it. Don't overuse it. But if you've got a specific question or you've got something related to the point that I'm otherwise making on the video, absolutely put that down. It'll highlight your comment or question for me, and I will be able to respond to it a little bit better. So as a practice round, I see here, Henry Lewis has said, hello, Hoeg Law. I was wondering if this co-op law doesn't affect rail fanning, if you can answer. Unfortunately, as a first example, I don't know what that is. Co-op law, either COPPA or something else, and I don't know rail fanning. So I apologize, but if you want to send that question back in, I will try to answer it my best to the best of my ability. We also have a question from Terrence Caron. My first question would be, have you got any examples of how delays are included in publisher-developer contracts? Is there any penalty? Do you always need to negotiate? Yeah, so presumably that's because of this big, long week of video game delays, right? And the one thing I would say here as well, I have to get used to doing a little bit of this maintenance and housekeeping at the front end of these videos, so I apologize, is if you've watched Virtual Legality, if you've seen the description of these videos, you know this isn't formal legal advice. Don't act on this in your own personal situation. Don't take it to be official advice for how you should handle a specific legal problem. I think this is educational. I think this is illuminating to talk about things in pop culture and otherwise that are otherwise popular and that you see on Twitter or in your social media feeds, to kind of give a little bit more education and information about how the legal system and how business in general operates and works. But if you need official legal advice, you got to go talk to specific counsel on your own, because everything is going to be related to your own specific facts and circumstances. So that's the disclaimer. Now, talking about delays, we had a number of video game delays this week, right? We had Final Fantasy VII Remake, we had the Avengers game. Both of those were Square Enix, so I think they announced them at roughly the same time. We had Iron Man VR delayed, and of course we had the big one, Cyberpunk 2077. Now, to some extent, those are going to be publishers in and of themselves. That's probably Square Enix deciding to delay it. That's probably CD Projekt Red deciding to delay it. I don't actually know who formally makes Iron Man VR, but the answer to your question, Terrence, is that every contract is going to be different, and video games in particular are essentially the infants of software, which are already the infants of kind of business contracting. Software is still new enough that there are certain kind of best practices. There's certain ways that we expect things to look from a kind of software as developed application basis. But even then, we've now got software as a service. We've got other concepts that have been added in the last 10 years that people are still kind of getting mature in their documents, in their contracts. So the answer is yes, absolutely. When you are a developer and you agree to something for a publisher, you're going to enter into an agreement that is generally based on milestones. You're going to get payments based on milestones. You're going to have to hit certain dates of approval from the publisher, things along those lines. And if those start falling away, if you start missing those are conversations that you have to have with your publisher. The way I usually tell clients about how contracts work on this is that you've got black and white words in your document, in your contract, right? And those establish what everybody's obligations are in a kind of entirely neutral sense. If everything works exactly as was originally planned 2 years ago, 3 years ago, 5 years ago, great. But we all know that that doesn't always happen. It maybe doesn't even often happen. So what we do with contracts is we say, okay, you've gotten to a place where essentially this obligation or this funding has to be amended because things haven't gone as we've expected. And so you have a First Amendment to your contract. Maybe you have to amend and restate the whole contract if the entire project changes on a fundamental level. And at that instant where you go and you say, hey, we know we are going to miss this test, Mr. Publisher, we need to amend something. We need to change how the contract functions. And so the answer to your question in kind of long form legal speak is that yes, there's always going to be that moment where if you're not hitting what the contract contemplated, you're going to have to talk about what an amendment looks like. There can be penalties built in. There can be liquidated damages. There can be just funding reductions. Hey, you're going to get $2 million if you hit this date, and then you lose $100,000 for every month you're late. Or whatever it is. It really depends on what the project is, what the relationship between the two parties is, who has the leverage at the front end, and going forward from there. So Henry Lewis has come back with his question. So it's COPPA. And then there's a film, Trains Here, that was marked my channel as not made for kids. I don't know whether it's your channel specifically. Again, we can't talk about people's specific legal situations, but the COPPA issue and whether or not YouTube automatically flips you into Trains for Kids or flips you into Directed for Kids is going to be kind of separate conversations because the COPPA law says if you are collecting this data, you have to go give notice and you have to go get parental consent. YouTube doesn't want to do that at all. So YouTube comes back and says, all right, what we're going to do is we're going to enable our systems to say, if you are remotely close to being directed at kids under the COPPA law, we're turning off all our widgets. We're turning all our levers. We're hitting all our knobs. You don't get anything. That's why comments turn off. That's why everything that YouTube does basically turns off if you have that button hit to it. But that was YouTube's choice. If you go and you look, and I know I have 20 videos in YouTube at large on this at this point. If you go and you look at this issue, what COPPA actually asks for is that notice and consent. What the settlement with YouTube says is you will now comply with COPPA, And what YouTube elected to read from that is, okay, anything that's remotely close to kids, we're going to turn off all our buttons. And that's led to this conflict between creators and YouTube, especially on kind of the middle stuff, right? Sounds like there's a train channel that has this issue. Yeah, you can see how YouTube's algorithm, or even somebody at YouTube, would look at somebody working with model trains, say, or something along those lines, and say, that is for kids because they're small and kids like small things, and here are trains. Obviously, that doesn't make much sense in the real world. It obviously could be built for kids. There could be cartoons. There could be a giant walking dinosaur related to those trains. But in all likelihood, this question is being asked because it's not that. It's actually adults working on very complicated trains and models and things along those lines. I've been to train shows, model train shows here in Michigan, and they're a lot of fun, but they're clearly people's passion and hobby. And you wouldn't expect some of the stuff that they do, like getting all of the paint and texture work on their buildings and things along those lines, to be very attractive to kids. So one of the issues with COPPA, one of the issues with YouTube, and really how it's all kind of playing out right this second is it is very likely that there's going to be a lot of false positives on the YouTube side of things because they can't otherwise identify what should fall under COPPA and what shouldn't because the FTC has left it so ambiguous in their own definition that they provide. So it's kind of a domino effect of YouTube trying to prevent liability, the FTC really trying to make sure that it has as broad a base of power as possible, and what you're left with is questions like Mr. Henry Lewis posed, which is what about train channels and things along those lines. Same goes for Lego, same goes for those kinds of things. But which is a great segue to my very first kind of video of the week. And I did want to thank Terrence Caron for the super chat, small super chat for your response. Thanks, Hoeg. I very much appreciate it. This is very cool. You guys are very generous, and I really do appreciate it. The first video of this last week was called Making COPPA More Harmful, YouTube and Protect Kids. And this was brought to my attention, I think on Twitter. It might have been in a comment to one of my previous videos. Again, I only have so much time to go find topics for these kinds of things. I do have a legal practice, my own law firm, and other things of that ilk. So if you've got something that you think might make a good virtual legality, if you hit me on Twitter, if you leave a comment to my video, I will probably see it. Those aren't as obvious to me as the mentions on Twitter, but let me know, because I would love to do more videos that people respond to, that people want to know the information on. And I certainly am entertained by certain things that maybe not all of you are, and we're going to get to one of those videos that I did because I thought it was fascinating in just a second. But this video was talking about a bill that was proposed by what is called a bipartisan group. It's one Republican and one Democrat, called Protect Kids. And the reason I did a video on this is that COPPA has long been kind of a thorn in YouTubers' sides, and they've been coming to me and asking for questions about how it operates. And I've said, hey, you can leave these comments, you can sign these petitions, you can follow X, you can follow Y. But don't be surprised if the FTC really wants to actually make COPPA stronger and not weaker. That for a lot of legislators, for a lot of people working in these agencies, YouTube and kind of the entire content creator paradigm is alien to them. And so it's very easy for people of that ilk to have told to them all of the bad things that could happen on the internet or on YouTube. And this is actually a function of that. Now, I saw in a lot of comments, and we might be jumping ahead a little bit, that they were saying, oh, the FTC is just trying to grab more power. This isn't actually an FTC play directly. This is the actual representatives in the House of Representatives in the United States that are proposing these changes. And the primary change that they are proposing that is getting actual coverage is that they are proposing to increase the age of what a kid is from under 13 to under 16 to kind of incorporate the middle, early teenage years as needing this protection from COPPA. And if you've been following along, basically the way YouTube has operated here is that they have been, in fact, kind of labeling things as for kids, hitting people as for kids that are remotely related to things that are under the age of 12. And the purpose of my video was to say, hey, look, this is actually going to be more trouble than it is at just under 13 as an age. At under 16 as an age, you've brought in a whole lot of kids that maybe are going to be attracted to what we consider adult fare. And I brought up the reference to the fact that video games and labeled M for mature are kind of funny categories for what it means to have adult content in them, violence or sexuality or swearing or whatever it might be. And so in this particular case, I think that creates a significant amount of issue that I've called it here in this video, making COPPA more harmful. But if you give increased ambiguity, increased power to the Federal Trade Commission on these types of questions, one of the major issues is that with that increased power comes a lot more discretionary penalty. And for the people that are coming into my Twitter or on YouTube and are saying, hey, I don't want to have a $42,000 some odd fine come after me, and I've tried to assuage some of those fears in certain respects. If you increase kind of the coverage of this already ambiguous law, you've got a lot of people that are scared, that are concerned about the content that they're making, because, you know, what is attractive to a 15-year-old and what is the distinction between being attractive to a 15-year-old and an 18-year-old? We start to get into some very difficult questions, and we start to get into some very difficult areas for people to respond to. And I'm seeing a bunch of comments in the chat right now that says I am laggy. It is possible that is on my end, so you can tell me if that's being corrected at all. We have a couple of streams going, I would be willing to bet, in this house. I have young kids who enjoy their various programs, and it wouldn't surprise me if either one or two streams are going at present. So do let me know. Otherwise, oh yes, it says here right now, look, YouTube is not receiving enough video to maintain smooth streaming. As such, viewers will experience buffering. So let me know if that winds up getting corrected at all. We didn't have this problem last week, but I don't know what the situation in my own house was. So it's as ever, an open question. Hopefully it's not too much of a problem for you. We've got some video backgrounds, and we're going to be looking at some comments directly. But for the most part, this should be me talking, so hopefully that isn't getting too problematic on all this stuff. And we did just get another super chat, which I do again appreciate, from Uncivil Law. See, your channel is growing nicely. Excellent. Been loving the COPPA work. I have learned a lot for sure. Good work. Again, I don't know what to say. You guys are just incredibly generous. I very much appreciate it. And it is very nice of all of you. And I do want to keep doing this and having these conversations with you. Hopefully on some stuff that, you know, isn't existentially terrifying to creators and folks that are operating on YouTube. I feel kind of bad for, you know, a lot of people finding the channel in this kind of what is viewed by, I think, a lot of people as a crisis type situation. And hopefully I've been able to assuage folks on the crisis nature of the thing. I don't think that it's necessarily something that should keep you up at night. But it is certainly something that everybody needs to be aware of if they are operating in this space. But with that said, let's talk a little bit more about this COPPA video, see if we can respond to any comments that people might have on it. And I didn't actually look at these in advance, so we'll see what people have here. It says, hey, makes me proud to almost be in my 30s, but don't treat teens as if they were to be lumped in with preschoolers. You know, I agree with that completely. I think that's one of the major issues here, is that that's a broad swath of development. And if you bring them all in, I think it just creates major problems, even for the FTC. You know, we've talked a lot in Virtual Legality about the fact that agencies want to collect power, they want to exert power, they want to use it in a specific way. And that's true to a point. They don't actually want to exert power and get into a bunch of kind of ambiguous situations and have people challenge them and have a lot of goodwill expended in bad ways on press that aren't in favor of what it is that they're saying or what it is that they are doing. And I think you do run the risk, if you attack all of YouTube and things of that nature, of hitting those kind of people where they live. And in this particular situation, I do think one thing that I should raise, and this came up in a number of comments, is that this is just a bill at this point in time. This isn't the law. It's unlikely to be the law. And I say that not because I understand exactly what different representatives are thinking on this particular bill, but just that there are a lot of bills that are actually introduced at the House of Representatives level, and the vast majority of them don't see the light of day for a while. And maybe don't ever even come out of committee to be discussed on the entire floor. And so when we talk about bills, I think it's worthwhile to keep your eyes on these kinds of things. I think one of the comments let me know that this has been introduced in various forms before by at least one of the representatives that introduced this version. So again, it's not a situation where you need to go, oh my goodness, this is going to pass, I need to panic. It's a situation where you say, that's interesting. If that happens, there are very bad things that would happen along with it. We need to keep our eyes on this particular bill. Let's see. I've never seen an organization so dumb before. They're saying 15-year-olds are kids. I think that might be related to the FTC. Again, the FTC didn't ask for this, as best I can tell. We have another couple references to the FTC. And then I'm okay with the intent of COPPA. I probably wouldn't object too much if they didn't characterize YouTube's end users as operators and kept the onus on YouTube where it belongs. 100%, absolutely. If you have been following Virtual Legality at all, you know one of the very first videos we did in YouTube at large was really about how COPPA probably shouldn't apply to people that put content up on YouTube that operate these channels solely to kind of put out whatever videos they want to put. They aren't actually deciding what the data collection policies of the website are. And COPPA was designed to hit at the people that are making those decisions. And the kind of theory that gets you at content creators and YouTube channel quote-unquote operators doesn't really make a lot of sense for what COPPA actually says that you have to do. Said another way, if you're creating content on a YouTube channel, there's no functional way for you to actually go and get consent from the people whose data you don't know you're collecting. So there's no way that you can actually comply with COPPA, which is one of those areas of law where you say, hey, it probably shouldn't be read that way, and is absolutely one of my primary complaints that you can see in the entire video series. We've got some other comments that say this bill is coming from a generation of people who think everyone is the boogeyman and all persons are up to no good. Yeah, we talked a little bit about that on the video. We said, yeah, this is of the ilk of, oh, there's a predator around every corner, the dark web, a few too many episodes of SVU, however you might want to frame it, that tries to hit things that maybe don't need to be hit. And in so doing, captures a lot of well-meaning, well-intentioned, probably trying to be law-abiding people that want to put up their train videos or want to put up their cat videos or anything else. And the situation is such that, in my opinion, that's an unjust result, right? I understand COPPA. I'm, in fact, in favor of the philosophy of, hey, if you're going to go collect this data from really young kids, you have to go get their parents' permission. But then go get your parents' permission. Don't try to figure out all these different various ways to get around it, as YouTube has done so far. And I think that's the basic thrust of most of these comments as I'm kind of scanning through them at present. There's some people that brought up Facebook and how it operates. That might be something for another Virtual Legality. I'd have to really look into exactly what they do with data, because one of the problems that YouTube has is that they kind of have this passive collection that happens even if you're not logged in, which I don't know if it has an analog for Facebook. I don't know that you can actually use Facebook that well if you're not logged in, but it could be something that is worth looking into. And then the last thing I would say on this video, and again, I highly recommend checking it out. Obviously, I made it if you're interested in these kinds of things, is there's a second part that I've kind of called out that would essentially flip how COPPA works right now. So right now, COPPA says if the parents refuse to allow you to use the kids' data, you can go tell them, okay, we can't use that data, but you can no longer use this service. And that makes sense, because you could actually build your application or your website or your service to need that data. There are things that need data. You know, if you think about something like Pokemon Go, it needs geolocation data to operate. And so what they swapped in this proposed law is, instead of saying you can turn it off if they deny you this data, they said you have to continue to provide the service even if they deny you this data. And so what I pointed out in the video is that that's ludicrous, that's crazy, that's going to break business models. That's legitimately going to affect the development of applications in the future, as well as the operation of existing applications, because there needs to be a way to say, okay, yeah, absolutely, if you don't give us this data and we need it to operate our thing, not we need to sell it to Russia or wherever, but we need it to operate how our thing works. If we can no longer do that, this thing can't exist in that form any longer. And so that, I think, would be an actually destructive event, an actually destructive application of this law, would be to have those applications no longer exist. And even when parents might otherwise be okay with their existing. If 99% of parents are okay and 1% would deny them the use of the data, but you still have to provide that service, then that service can't rely on that data. You can't have a functionality that uses things like geolocation data. If a kid's parent might otherwise say no, and it might otherwise attract a kid to be on the application. So I think you really have to look at laws like that as silly in the way the internet works and the way application development works. And it's all well and good to be on Virtual Legality, to be on YouTube and say, yeah, this is silly, Rick. It's quite another thing to actually have a developer who's maybe worked on something for 2 years have this law pass and get into a situation where at the end of the day, they don't have a development, they don't have an application that they can actually sell because it has been made illegal by executive and by government fiat, which is not how I think we should operate. Different reasonable minds can differ on these kinds of things, but that's why I described the new proposed law as harmful, even more harmful than the existing COPPA. So before I move on to the second video of the week, because this was a big week, we actually did 4 this week. I did want to look at the chat. Maybe replace the screen capture with a still image, Hoeg. Yeah, could absolutely do that. What can we do with this new legislation to try to avoid some of these new changes? Contact our legislators. Yeah, if it gets a little bit further, kits and caboodles, I would say that would be about the time to go say, hey, don't vote this up. Right now, the bill has been proposed. It has to be kind of evaluated by various groups, subgroups within the House of Representatives. Personally, I think it'll probably die, but I don't like to guess at these things because whoever knows what pops out of the House of Representatives. But if it doesn't die, then it'll be proposed to the whole House, and then you'll still have another bite, really, if it somehow gets out of the House of Representatives to go and talk to it when it's being evaluated by the Senate. So you do get some time period to kind of discuss these things with people. We've got some nice comments. This is the first time I'm seeing you live. This is only the second time we've ever tried to do it live. We've apparently already had a lagging problem. So I don't know what's on your screens right now. I'm currently looking at the front of the Sony episode of Virtual Legality. I apologize for the difficulties there. We will try to address that again in the next video. I think it's worthwhile to state that I expect these to have a certain amount of technical difficulties for at least the kind of first couple that we do, if not forever. You never know. I am still, I do software, I do technology, I do all of this stuff at my law firm and otherwise. I still occasionally drop the call when I'm trying to transfer into a conference line. So it is what it is, and I will do my best to try to give you the cleanest, smoothest experiences possible on these kinds of things. But you will have to accept my apology in advance. It's just me putting these together, and I will do my best. Finally, all of this talk about COPPA makes me think of The Simpsons with Mrs. Lovejoy's think of the children and her hand wringing. LOL. Yeah, I mean, that's absolutely right. There is a lot of law that is motivated by think of the worst of us, think of all the potential problems, if only one person could be saved, et cetera, et cetera. And I do think they need to be balanced a little bit more. I think that needs to be part of the conversation. And I think there are a lot of representatives and senators and people in other positions, governors, wherever it might be, that do take those into consideration, that do try to get kind of an understanding of both sides of the conversation and hopefully result in something that is useful and workable for a large swath of society. I can't promise that happens all the time or even most of the time, but I think it does happen from time to time. And so it's not all cynicism here in Virtual Legality. There are people that are trying to make the world a better place, even if we disagree about how they're going about doing that. So the second video I did of this week, which was actually put up the same day as that video because this news came out and it was just super interesting to me, video game wise, about Sony not attending E3, the Electronic Entertainment Expo. If you're not familiar with it, is the big conference that happens every summer where the big video game companies come and they do big shows and they talk about their games coming out in the next year or the next 3 years, depending on which publisher you're talking about and exactly how many times they get delayed. But Sony dropped out this year. They dropped out last year. That's not really the interesting part of the story. The interesting part of the story for me was doing this as a corporate messaging analysis. So if you've been following Virtual Legality, you've probably seen we do a lot of kind of talking about corporate speak and what people are trying to achieve when they put their press releases out and what they are trying to achieve when they otherwise communicate with their fan base or with the press or with other stakeholders that are related to what they are doing. And for Sony and the ESA, they have wildly competing visions of what E3 should be, really probably what the trade show circuit for selling video games should be. And this one's a shorter video. I think it's only about 15 minutes. I see here it says 1809. But the crux of this video is that Sony goes out there with a statement that says essentially, E3 isn't what we want to do this year. We want to go and we want to be closer to our fans. We don't want this to be just a business trade show. and they add a little bit of spice in terms of corporate speak. They actually say the vision of E3 for this year doesn't match with what we want to do, rather than just saying E3. And the vision of E3 is something that's entirely orchestrated by the ESA, the Electronic Software Association. And they put together this show every year. And by calling out their vision, they are basically saying that the ESA isn't doing the job that they want them to be doing for this year's show at minimum. And the ESA responded with what I can only describe as corporate gobbledygook. So like all of our videos in Virtual Legality, we actually go and we put the links in all these things so you can check out what the ESA actually said. But they started talking about activations and brands and various things that sound directly out of the Harvard Business Review or various kind of boardroom PowerPoints that you might have seen if you're familiar with how those things generally look. You know, they're synergizing, what have you. And so I did want to call out in this video that it's very, very interesting how these two different sides view things, and that this is pretty much as close as you can get to two people or two industry titans that are ostensibly aligned, calling each other out through corporate statements. It's very rare, because the ESA statement, even though it's in corporate gobbledygook, winds up saying essentially, hey, the people that really care about games will be here to try to assuage the other participants in their show. Don't worry about Sony. The people that really care, they'll be here. And that's pretty much as close to kind of what we might call on the internet shade as you'll see these two kind of heavyweights throw at each other. Yes, Terrence Carano, who I think is in chat, actually said, yeah, people haven't talked about the ESA response yet. And so I appreciate it for the video. Some other nice people said this is a very good explanation for what's happening with Sony and not out of one of the YouTube gaming channels. And I say, yeah, we're not officially a gaming channel, but we do talk a lot about gaming. That's obviously a passion of mine. I have a lot of clients that are in game development, a lot of smaller folks, not big publishers in general, but a lot of smaller independent companies and developers that have a lot of questions and need some help with software licenses and things of that nature. So I do love gaming. And so you will see me talk about it from a corporate perspective. You have a lot of comments here that talk about kind of the end of E3. And I think I put it up on my Twitter. I think there is a kind of feeling that this is the moment that E3 ends. I think it's the E3 that we knew, which frankly was only around for a decade. Their E3 has gone through various metamorphoses. And when I started watching it, it was almost solely what I would consider kind of a business event. PowerPoint trade shows about sales figures and demand curves and EBITDA and things like that, which, because I'm a weirdo, I enjoyed. But certainly it became more of an entertainment show. And now I think it will change. And will it change to something that Sony wants? Will it change to something that somebody else wants? Will it change to something that nobody wants? I think that is up for grabs. But certainly the fact that these companies can now go and have videos on YouTube that talk directly to what they want to talk to, they can have their own events, they get all the spotlight anyway. That changes the need for E3, and that changes, really, honestly, what it's likely to look like going forward. All right, Terrence has flagged me. It says, about Sony dropping out of E3, do you think it's more about reducing cost or changing the approach to adapt to a new landscape, or maybe both? I think functionally these companies like being able to control their narrative completely. I think you think about those times when the Sony demo for, Uncharted kind of quasi broke. They don't like that. They don't like that look. And I think there is very, very little fall off to an E3 press conference to a Nintendo Direct. And those get to be polished, they get to be edited, they get to be cut to a shine. And I think Sony, through their state of play videos, which aren't as great as the Nintendo Directs right now, but they're getting there by just copying Nintendo Directs entirely, they're trying to get to a place where they can control that narrative entirely. I think also, from their statements, there is a general negative feeling towards the ESA's leadership and whether or not they have their finger on the pulse, they even know what E3 should be. So without that kind of leadership, without that trust in the direction that the ESA is moving the show, I think what you've got is the combination of it is very expensive to be at E3. And if you don't trust that E3 is actually going to be what it should be for what you're trying to achieve, you have every reason to say maybe we cut that expense. So I think it's twofold there. But that was our second video of the week. If anybody has any other questions, anything they want to raise before we transition to the third idiosyncratic video, the first time we really talked about tech companies outside of software in the internet on Virtual Legality, please let me know. I see here somebody just saying what's going on over here. We're talking live about the Virtual Legality videos of the week and comments that people might have had on them. And hopefully answering any questions that people have that aren't raised in the comments to these videos. Just generally having a good time. You know, it's Saturday afternoon. This is a good time for me to be kind of separate from the more intense legal drafting and opposing counsel negotiations that make up the stressful portion of my job. And this gives me a chance to talk to you all and see what areas you think maybe weren't covered that well in the videos that I already did, but what areas of the entire industry or elsewhere you don't think I covered in Virtual Legality or that I should cover next week. And hopefully I can have these conversations on a regular going forward basis. We will see. We will see what kind of time my schedule permits, what kind of time my family's schedule permits. But I do like doing these. I did one last week as kind of a test case. It worked pretty well. And so that's what we're doing here. Which brings us to our third video of the week. 23andMe just sold your genetics. Why you won't be getting a cut. And so I was looking at various articles, as I do when I'm between negotiations or at the start of my workday. And I saw this article because 23andMe is one of those things that I've always found fascinating. I'm the kind of guy that doesn't love to turn in information to third parties, doesn't love the Alexas of the world, doesn't love somebody else having that information, because I understand how these data policies work. I understand how there are various, if not loopholes, just uses that people can do with the things that you give them that you might not be expecting. And so 23andMe is one of those that I followed for a decade, really, as they collected this. And I said, well, they're going to monetize that information somehow, someday. And really, this past week was the first time we saw the full business plan in full regalia. And that was with 23andMe actually using the genetic data that they had collected from their 10 million plus users and using it to frame out a test case, a test bed for the creation of a drug compound whose formula they then licensed out to a pharmaceutical manufacturer, Almirall. And presumably, those kinds of licenses generally make a lot of money eventually. Presuming that drug passes the other regulations that it needs to pass and it gets out there into a commercial level, that is ultimately going to make 23andMe a significant amount of money. And there were a number of medical ethicists and business ethicists that came out here and said, hey, that's people's genetic information. Pardon the alerts here. I understand that Children of Morta is now available on Game Pass for anybody interested. But that these ethicists were saying, hey, those people that contributed their genetics should be allowed to go and get some portion of the money. I said, hey, that sounds like a virtual legality, because I am sure that their terms and conditions are very clear on this, that they don't get any portion of the money. So this video was basically about diving into the terms and conditions of 23andMe, looking at the way their privacy policy works, and then ultimately asking for a few folks to give me some links to what was going to be their consent document. So one of the things that 23andMe said was, hey, this only applies. We only collect the data from the people that formally, explicitly consent to its use for research. And so I thought that was interesting. There wasn't actually anything that I could find that I could jump straight into, although I might have missed it, which can happen. I'm a human being like anybody else. And certainly some people linked me the actual consent document, which I am very much appreciative of. And I looked at all this stuff and I said, yeah, this is express consent to use it for research. You've got some sentences that say you won't financially benefit, kind of in a different document, in a different paragraph. However, the question remains, were people expecting that kind of result? And so I wanted to walk through how the terms and conditions get you to the fact that 23andMe can monetize this, can sell it to pharmaceutical companies, can make all the money, and that how they got to 80% consent on this kind of stuff. And they use very, light language. You're helping the human race, essentially, by checking this box, and you weren't going to make any money off of it anyway. And I think that's true to a certain extent. But, however, I think that 23andMe has been around long enough, really into the last decade, or I guess now 2 decades ago, since we're in the 2020s, that I don't know that people had the same kind of sensitivity and understanding and really focus on what's happening to the data that they provide. When 23andMe started, there wasn't necessarily an understanding or an expectation that when you go and you send the saliva in and you get this report back, that information was 23andMe's in part, that you were licensing it to them for this use, for these sales, for these drug formula creations that they can license out to pharmaceutical companies. And yes, they kind of explained that in the consent document that was sent to me. I don't have a problem with it, assuming that people get to that full understanding, but I do think that could be better kind of communicated. And so that was the purpose of the video. I wanted to kind of talk about it. I want to talk about why, medical ethics doesn't actually matter when you're talking about these kinds of contracts here. We can talk about whether it's a good thing or a bad thing, but certainly 23andMe appears to have buttoned up all that it needs to button up to do what it did, which you would expect from a company that really probably has this as part of its end game for really making a lot of money. And so that was the purpose of this video. You see in the comments some people talking about this, essentially saying, hey, people should know what to expect from people that take data. And yeah, I think right now you'd have that sensitivity. So I think if somebody signs that consent document now, I have kind of a less of a concern about it than the people that signed it in, say, 2006. When one, we can't really read what it looked like back then. I didn't see any kind of directions to a version that old. And two, there just wasn't that sensitivity. But those are the basic comments here. I don't know that there are any specific questions that I can recall here. There is somebody in this video comments that tipped me off to what wound up being my next video. So again, if you've got a video you think I should cover in Virtual Legality, hit me up on Twitter, put it in the comments to these videos. I do try to read them all and find something that I think would be interesting. But ultimately, that was the point of this video, to do a deep dive on terms and conditions that weren't associated specifically with an internet tech company, because I do think there's some interesting stuff there. Certainly in the 23andMe terms and conditions, I found one bit of language that I absolutely loved that was essentially like 23andMe warns you that use of the service could alter your worldview and philosophy or something along those lines. And I said, hey, it's the very rare contract that can put in essentially a scene from The Matrix and put it directly into its terms of service and say, hey, if you use this, it might just change your worldview. And I got a kick out of that from the lawyer perspective. I don't know if any of you got a kick out of it specifically, but it's such unusual contract language. And I could just think of the lawyers saying, hey, we need to warn people that this could change their entire philosophy. And I think that's good stuff. So before we hit the fourth video of the week, let's see what else we've got. We've got Terrence saying, hey, I don't think State of Play has the same resonance as an E3. I don't necessarily disagree, but I think it's close enough that when you're talking about huge amounts of money, it's easy to say, hey, if it's a lot of money and I don't trust the ESA, then we'll just stick with videos. Thank you very much. We've got someone saying, hey, cool to catch one of these lives. Thank you for the COPPA videos. My pleasure. I love doing these kinds of things. Thank you very much for the comment. Great time for this live chat in Sweden. Most US-based live chats are when it's night here. Thanks. Hey, all right. I'll look at what time that is. But yeah, probably if we start doing these on a regular basis, they're going to be somewhere in the middle of the weekend. That is the most likely time that I'm going to be available to do one of these, and that I won't wind up with a divorce or otherwise make my family upset at me. Otherwise, the week is usually kind of taken up either with putting out a video, which takes a couple hours, but most prominently with actually running the law firm and being a lawyer on a day-to-day basis. So what else we got here? Yeah, it's 7 p.m. for once in an American stream I can catch. Awesome. They're not very accurate, I read. Presumably 23andMe. I don't have any personal experience with the accuracy of their reports. I suspect they will get more accurate as more and more people actually submit their data. It's kind of a network effect, I would guess. That tends to be how research works. And it's one of the reasons that they can license out the genetics. They can use it for this purpose, is that with that number of people agreeing to research, it gives you a scope that it's very difficult to match in kind of a testing or kind of an expense side of the ledger. So it's no doubt to me that this was always part of their business plan. They would have been silly if it wasn't, but that doesn't mean we can't dive into their terms and conditions. If a child orders a 23andMe kit and mails it in, signing the consent agreement, and then parents find out, do they have liability selling children's genetic data without getting parents' consent? Probably. The issue there is you've got a fraud on top of it, but you've got a child who can't do the fraud. So basically, if you go and you look at the terms and conditions, which we covered in this video, 23andMe goes and they say, you are promising that this is your saliva, essentially. And you can't send in somebody else's saliva. That's not allowed because we need this consent. It's going to be personal health information of a kind we aren't used to seeing, in all honesty. And if you are going to be a minor, you have to sign for the minor as a parent. Now, what you've proposed is that the child goes around all this and essentially claims that they are their own guardian or that they're above the age of consent, and then they've got this data. I think that is potentially a difficulty for 23andMe. They could probably destroy it. They could probably remove it from their research packages when they get notification that that happened. But in the first instance, generally speaking, if they put those kinds of things in their contract, if they require that kind of certification, they've done the best that they can on a kind of good faith basis. And so while there might be a circumstance that could come up where it would be a legal issue, I suspect by removing it, by saying, hey, don't let your kids sign documents, they could probably be okay from a liability perspective. Can't guarantee it. These are novel questions. I could certainly see that being something that would come up in a trial court in a very specific set of circumstances. Maybe if a kid finds out that his father's not his father, that kind of thing where you've got real significant issues and they never should have given the information. I could see that becoming a kind of litigation just because of the optics of it all. But from a legal perspective, it's difficult to see what 23andMe could do more to protect kids on that basis. Let's see here. Hoeg, do you think Sony is losing a PR opportunity by skipping E3 again amidst the PS5 ramp up? I think it would be best if E3 worked for everybody, every stakeholder involved in the game industry, but I don't think that they are going to miss an opportunity. I think that they're going to have a PS5 show. I think they would have had it separate from E3 anyway. I think the PS4 was shown in like February or March of 2013, something along those lines. So I think they're going to do the same thing this year. Expect it in the next 6 to 8 weeks. And I think that always would have been the case. And yeah, I think it would have been nice to see at E3. I think it would have been nice to have a hands-on, but I think they'll hold their own event. I think they will have a hands-on with journalists and things of that nature. Honestly, this is one of the stranger generational transitions we're about to experience. You don't have kind of the obvious massive increase in graphics or performance or things of those lines, and you have Xbox coming out and saying there won't be any exclusives at launch. I mean, there's a whole lot of interesting things that are related to this transition that I think maybe make it less of a big deal that they won't be showing up at E3. Red pill terms of service. Yep. Matrix references. I like to be on the cutting edge. So only references from 1999 here at Virtual Legality. I like new treatments happening because of that kind of genetic collection from 23andMe, but that's a lot of money to pay for data that isn't exclusively yours. That legal language should be more prominent. I actually agree with that. I think I referenced it in the video. I would expect that kind of thing to be very much up top. And they actually kind of push the you won't get financial benefits off to the main terms of service, and it's separate in the consent document where you essentially agree to help the human race. And so that's a way you can construct it. I don't necessarily blame them for constructing it that way because they want a maximum amount of checkboxes in the contract, but I think we, outside of operating 23andMe, can look at it and say, yeah, I would put that in a big underline, maybe all capital paragraph at the top that says, hey, if you agree to have this allowed to be researched, your data will be aggregated, sure, but you will never make any money off of this, and 23andMe expects that it probably will. And if that's still okay with you, check the box. Thank you for helping the human race. But moving forward, you won't get any money, and you shouldn't expect any money. I think that could be highlighted a little bit better. We've got a couple message retracteds, which I'm going to assume were personal insults directed at me, so I appreciate it. When I heard you can sell your genetic data, my worldview changed. Sure, go watch Gattaca. It's a great movie from the 90s. And then PR opportunity. Thanks, Hoeg. Love and respect. Yeah, absolutely. No problem. And so I think that brings us up to speed. I'm doing a better job. This time people aren't hurling quite as many comments at me. So I feel a little bit less under fire, which brings us to the last video. Popping back into the world of juke media, infringement, copyright strikes, and the rest. If you were on the last live stream, we actually did it to talk about questions and answers specifically to our first juke media copyright infringement video, which was about MXR plays and about whether they were being extorted by juke media, answering all those questions, hopefully. And that actually wound up being what turned out to be our first 100,000 view video on the channel, which, as a lawyer that kind of started doing this to figure out how to put something up on YouTube, exactly what kind of data some of my clients were seeing, and which has blossomed in a way that I am, pretty thankful for. I'm very appreciative of the people that checked it out, the people that left comments, and that hopefully were a little bit illuminated by what fair use is, how copyright infringement works. It wound up getting quoted on Legal Eagle and various places like that. And so I'm very appreciative. Nobody's making personal attacks, Nick Krandos. It was a joke. I assume message retracted was covered in a different question. I was just having fun with the fact that, as you probably know, YouTube is a place where a lot of people say a lot of things. And if you go to various videos, and they're probably not the videos that you're expecting, but if you go over various Virtual Legality episodes over the last month, you'll see a whole section of people accusing me of not having a bar degree or not having a law license, and that I shouldn't be saying anything about the law because it's clear that I am a biased idiot. Which, hey, I am more than happy for people to have that opinion. I'm more than happy for people to express that opinion. But yeah, that's YouTube. That's social media. So it's absolutely fine with me. Now, I have gotten the yellow bar again, which is telling me that they are not receiving enough video to maintain smooth streaming. So I suspect we are lagging once again. I personally apologize. I will look into this on the next stream to see exactly what else I could change to make this work a little bit better. But however that sounds or looks to you, I do apologize, and hopefully it is something that we can improve in the very near future. Continuing with this video, in this particular video, another YouTuber said that Jukin Media issued a copyright strike on their video service. Now, if you aren't regularly doing YouTube, one of the things that I have to kind of make clear is that YouTube has essentially two functions for when it receives a notice of copyright infringement. It can strike your channel, force the video to be removed, and if you get 3 strikes, I think 9 times out of 10, YouTube's going to remove your channel. You're not going to have access to it. You're not going to be able to use it anymore. Or somebody that comes and says, hey, you're infringing on our copyright, they can claim your video. And what claiming does is it essentially says, hey, we can run ads on this video, and those ads bring money to us and not to you. And the example I give on this video is, if you're familiar with our Game of the Year series on the channel, we talk about our games of the year. And I use trailer footage to do that. And most of it is fine. Mostly nobody claims anything. But there are a couple companies, Capcom in particular, that claims them. And I don't mind. It's fine. I could fight it. I think it's absolutely clear that it's not infringement for the use for those kinds of videos. But yeah, it's essentially something that can be done to claim your money and say, hey, this is our copyright, this is our information, but it's not going to otherwise affect your channel. There's actually a notice on YouTube that says, hey, this isn't a strike. Don't worry about this so much. You can fight it if you want, but they can fight back, et cetera, et cetera. And so what Jukin Media did to this YouTuber is they actually struck his channel, and he's complaining about it. He says, hey, they said, hey, you got to go get one of those retroactive licenses we talked about last week. If you don't want this strike, we can remove it. If you pay for those licenses. That was essentially the first step of the conversation that MXR Plays had. They apparently paid Jukin Media as a response to one of these letters before they got the bigger letter. That was the problem that they're now saying that they are extorted under. But I took a look at this channel. And to be frank, one, because the video that had the strike issued against it, you couldn't see. So I couldn't actually say what was actually being done in the video that he had the strike applied to. The rest of the video is reactions. And very much the kind of reactions that we talked about as being potentially problematic in the MXR Plays case, which is them sitting there and watching a video of something else happening, and in some of these videos trying not to laugh, those kinds of things. And whether or not that is actually sufficient commentary or critique on a video seems unlikely. And again, when we talk about fair use, it's a balancing test. It's a facts and circumstances based test. It's not something that we can jump out and say, yes, absolutely, this is fair use. This isn't fair use. This is parody. This isn't parody. It's something that we have to evaluate on a specific facts and circumstances basis. So without the video, I can't say even how I would feel on it specifically, but I can say that based on the rest of the content of the video, this is very likely a situation where Jukin Media can be a bad actor. We can look at how they operate and the communications that they have and how they kind of intimidate YouTubers and say, this isn't how a company should operate. We can say, no, we don't like how that is. On the other side of the coin, we can still say, hey, it appears there's a lot of YouTubers that are walking real close to the fair use line, if not over it, and they're making life difficult for a lot of people, because when you look at videos like this, you got real significant problems. And so it looked to me like this is probably a situation where maybe Jukin Media does have a claim. Maybe they do have a claim on the original YouTuber who this YouTuber is commenting on. And it kind of goes down. There's turtles all the way down. You can kind of describe what's happening here. But it's one of those situations where I would be uncomfortable saying, yes, absolutely, you are fair use. You are absolutely fine. Jukin Media is solely the bad actor here. I think once again, just like MXR Plays, you have a situation where there are double bad actors. So I wanted to use this video to kind of talk about the DMCA, the Digital Millennium Copyright Act, and takedown notices, and how they function within the YouTube ecosystem to create these kinds of perverse incentives for copyright holders. If we assume that Jukin Media has all the copyrights that they should have for something like this, how it creates these perverse incentives for them to do these kinds of things. Because the DMCA says, hey, you only have to have a good faith belief that something is infringing. Yes, we talk about in this video a legal case that says you have to consider fair use, but in that same legal case, it says basically that your subjective understanding of whether something fair use is fair use or not will control whether or not you get in trouble for issuing a takedown notice. Then it has this entire incentive structure for a company like Jukin Media to have a memo in their file folder that says, yeah, we looked at fair use. It's not fair use. We're good. And to issue these strikes, to have this conversation with all the leverage on their side, to then, if you pay them, issue the second letter after another pass of looking at your videos saying you're doing X, Y, and Z wrong. The DMCA structure and the way Universal versus Lens works as a court case kind of creates this environment. And there's a lot of things I blame YouTube for. You guys know that if you follow Virtual Legality and you follow our COPPA series. I think YouTube could do a vastly better job of protecting its creators from the risk of Federal Trade Commission action and from COPPA. In this particular instance, I don't really blame them for operating the way they do with respect to the DMCA. As a matter of fact, the claim process is actually them trying to soften the DMCA for their content creators, and I think in a very successful way. But the DMCA creates this safe harbor, creates a lack of liability exposure for YouTube if they respond to any copyright infringement claim that is certified in this specific way. The certification only requires this good faith belief. This good faith belief only requires a subjective analysis, and so YouTube is going to take them down whenever they see these kinds of things, and it essentially creates the Jukin Medias of the world to operate this way. And so that's the purpose of that video. It was something that I wanted to dive into. I wanted to cover it actually with respect to the MXR Plays video, but that was getting long enough, and so I took this as an opportunity to have that conversation again, because I think that's an important conversation to have. It's certainly an important conversation for creators to understand, because it's easy to kind of just be upset at the situation as it stands, flail at everyone. I don't blame you. I don't blame anybody for that. But in this particular instance, YouTube operating the way it does in respect to a DMCA takedown notice, I think is entirely something that can be anticipated by the way the law reads, and not something that I blame YouTube for really at all. And so that was the purpose of this video. Let's take a look at the comments right now, see if there's anything else here. Deleted messages is because you can't edit when you post in chat. Hoeg, no insults here. Yeah, no, I was joking. There are a ton of lives. Lag is just a YouTube reality. Many prefer StreamYard. They say it is better. I've seen it on both, so lol. We'll see. The first one worked just fine. There were a couple of lag points here. I'll definitely look at the recording to see how bad it is. But this is a very easy process for me to learn, and God knows I need easy processes to learn to do this stuff. So maybe we can check out some other buttons and some other toggles I can hit for that purpose and for archiving and things of that nature. But for right now, this is the set of levers I figured out how to pull, and so we'll be using this for the future for at least a little while. Thanks, Terrence Caron, saying he's leaving. I appreciate you jumping in. Hoeg Law, has anyone actually had a fine leveled against them for filing unauthorized DMCA takedowns? There seems to be no liability on the takedown issuer. Yeah, actually, the DMCA does have a bad faith kind of penalty requirement. If you go into this video, or if you go into the links of the video right here, there's a case called Lens versus Universal Music Group that doesn't get all the way to the level of imposing fines. It's actually a different kind of motion. But it says, hey, if you didn't bother to take into account fair use and you just issued a takedown notice, you have a bad faith liability that could be imposed upon you. The problem is the standard that is actually required of a copyright holder under that act, under that case, and really the only standard that's really been discussed right now, is not so significant that anybody that has any lawyers on retainer or otherwise can't put something in a file folder that meets that standard. So it's very difficult to imagine that happening, that somebody like Universal Music or someone else that's making a strike like this. Jukin Media are idiots if they don't have a file folder full of their quote-unquote fair use analysis and why the video that they are threatening doesn't fall under fair use. It's easy enough to do. You've heard it in virtual legality. The balancing tests can be interpreted in different ways. And because of that, their subjective understanding of what is and is not fair use is going to be something that is going to be a fairly easy bar for them to clear. And so unfortunately, yes, the law contemplates bad faith penalties. The rest of the case law since it was passed suggests that that's not a very difficult bar for copyright holders to clear. And so that's been that video. Let's see if there's any kind of obvious questions that I wanted to answer here. There are a couple people that jumped in with a lot of comments. There's some other people that talked about counter notifications. So if you're not familiar with how the DMCA operates in its entirety, go to the channel, look up DMCA. There are a couple of videos where we talked about this a lot with respect to a company called Stardock and their game Star Control, where they were under fire from the original creators of the Star Control product in the, I want to say, 80s and 90s. And whether or not their new game was infringing, and a DMCA takedown notice and a counter notice. That one actually had an indemnification agreement that went along with it. Good stuff. Check it out. But the point is that YouTube doesn't have the same liability for taking down a video of yours that it does for allowing infringement. So the law comes in and says you could be contributorily infringing on somebody else's intellectual property if you, YouTube, leave it up after you are told that it is infringing. So that's why YouTube takes it down. That's why Steam takes it down. That's why whoever takes it down, they get that safe harbor. The law then says you won't be liable for taking it down to the original content creator if they give you a counter notice that meets all these requirements and you put it immediately back up. The issue is you're probably not liable to that content creator anyway. If we dive into the YouTube terms of service, YouTube basically reserves the right to take down anything for any reason, however it wants. It's a private corporation. It can do whatever it likes with its channels. It's one of the other reasons why COPPA shouldn't apply, because you're not an operator of this website at all. But that is certainly an argument that we could have at a different time in another COPPA video. Sometime in the future, I am sure there will be one. But because of that, YouTube doesn't necessarily have to respond to the counter notification with the same alacrity that it responds to the initial copyright infringement notification, because it's much harder to kind of concept out the lawsuit that you would have against YouTube for pulling down your video in response to a DMCA takedown, because that's a rational act from YouTube. They don't really have liability to keep your videos up. Obviously, they take down videos that don't meet their guidelines all the time. They basically reserve the right to do it for any reason. And so counter notifications are interesting. For the most part, if YouTube doesn't have any other kind of person in that fight, they are going to put it back up when they get a counter notification, but they don't have to. And so that's going to be something that YouTube is constantly kind of dealing with. And so the DMCA is not a perfect solve to a lot of this. Obviously, it can be abused. Obviously, its language suggests how to abuse it. And that's one of the problems that we wanted to highlight in this video. And I think that's basically the thrust of most of these comments. A lot of juking stuff, a lot of the people that actually followed this YouTuber, Tyrone Magnus, saying, hey, he mostly does reactions. Reactions are a problem with YouTube all around. And I think that's kind of where I arrive at as well, which is Jukin Media is a shady company, and they're dealing with all these kinds of notifications that aren't very genteel, and they are abusing people through intimidation and taking advantage of their lack of sophistication on legal and business matters. However, they might not be in the wrong on the license rights that they hold and how they are being used by these various YouTubers on YouTube. So it's a very complicated issue for somebody like me, a corporate lawyer, to look at and say, yeah, I don't want to operate that way. I don't want the Jukin Medias of the world to operate that way. However, YouTubers, I think as a collective, probably have to do a better job of at least being cognizant of what fair use actually is, of commentary and critique and transformative nature and all these various things, and not just have a video where they watch another video and then say that's not infringing because it's a critique of some kind. You got to be more careful with this. Certainly if you're somebody like Tyrone Magnus that has more than 1 million subscribers, probably doesn't hurt to actually have a corporate attorney on retainer to go chat with about these various things, or to even pay them for a half hour to watch your video to see whether they think there's a potential issue here and how it might be changed, so that you try to get in front of the Jukin Medias of the world. Jukin Media could be issuing these strikes and making difficulty for things that are clearly fair use. I haven't seen that yet. So, if you have other issues of this, if you have other instances of this you want to share with me on Virtual Legality, absolutely hit me on Twitter, leave a comment to these videos. But I haven't seen them, outside of the way they are operating, kind of abuse the system for just attacking things that they clearly shouldn't be attacking. These YouTubers are giving them a lot of rope, and Jukin Media is really coming after them with it. And that's been my videos for this week. If you have any other comments, we'll be checking out the comments right now to this chat. I really do appreciate it. I really appreciate the people that have super chatted. Again, that's very, very generous. We love to do these things, but it does in fact take a lot of time that we probably should be billing. Fortunately, I'm my own boss, so it's an easy thing for me to say is efficient enough for our purposes. But it is always nice to see those kinds of things happen. I really, really do appreciate the generosity. Let's finish off with a few comments here. DeCrando says, does it bother you that Ross Scott appreciated the hours you spent talking to him so much that he made zero corrections or any changes to his video on gas after you pointed out the misinformation? I don't blame anybody for that. We linked it in this video. I think he linked it on his own channel. I view Ross as a person that really does want the best for the game industry, really does want to kind of try to figure out the archival situation. That's something that I myself want to try to figure out. I think that there is reforms that could happen with the copyright laws across the world, but especially in the United States, that could help archival of digital services and software as a service in particular. That should happen, honestly. Where I objected, the reason I had my video responding to him, the reason we had the conversation that we did was because the clickbaity nature of YouTube is you go out there with fairly strong titles, right? So he called games as a service fraud. It's definitely not fraud. The terms of service are pretty clear about what you are getting with respect to a license to use this thing, and that essentially the servers can go away whenever they go away. I think it's perfectly within Ross's rights to not like that fact. But the fact that he didn't issue corrections to a video, maybe it would have been nice to have a small corrective video put on his channel talking about some of the conversations he had with me and with other lawyers. But the overall video in and of itself doesn't bother me. I try to get the best educational information I can out there, try to inform people and what they do with it from there. We can only nudge, we can only try to improve the situation in terms of what people are talking about. I very much appreciate you coming to my defense on that, but I think anytime we can get good information out there is a win, regardless of what happens from there. Kits and Caboodles, basically in terms of morally right and wrong, Jukin Media is acting shady. Yep, absolutely. But in legal terms, they potentially have a case based on how they are being used in the reaction videos. Yeah, these could be infringement. I talked about MXR Plays. I would probably call at least one of the clips that I looked at probably infringement. Fair use requires a transformative nature. And you certainly had a lot of people come into the comments and say it is transformative because it's a longer part of a video, because they have their faces on it. I'm not saying you couldn't make these arguments. In fact, I'm not saying that these kinds of arguments won't be held to a different standard in 2020 than they might have been in 2010 or even 2000. You get into a situation where that becomes more of the expectation of how intellectual property actually propagates around the world and through the internet. You probably have a better argument than you would have 20 years ago. But the fact remains, I look at that and say, that would be something I would warn a client about. I would say, hey, I don't see commentary or critique here. I see you using the heart of their intellectual property. I think somebody could come after you for this. If you've already had an interaction with this company, you should try to make darn sure that this company doesn't have rights to every single video in your kind of compilation, because they've already expressed that they want to go get money from you. So take them very specifically as a threat to your channel and to your livelihood. But that would be advice that I would give. So I think that's exactly right in kind of describing it. It's why it's such a difficult kind of thing to talk about on the internet, is the fact that these people are doing things that walk right up to the line. Obviously, it makes them money. Obviously, it's useful. It's lucrative to them. They walk right up to the line, and then they get upset that somebody comes and says that it's infringement. And I look at it and I say, yeah, I understand feeling put upon. I understand that Jukin Media is shady. They could do better, but you could do better too. YouTubers. I've found that it's best not to help people who ask for your advice and do the opposite. Yeah, the internet, social media in general, if you follow me on Twitter, you'll see from various corners of various political spectrums, I get called all sorts of names, right? I usually view that as I'm doing a fairly decent job. If I'm called names from both sides of politics, if people like me on one side, like me on the other side, hate me on both, whatever, that if I can get information out there, if I can hopefully talk to people on kind of even ground. We don't do ad hominem attacks here in Virtual Legality. We don't do personal insults. We like to try to believe in the good faith of everybody that's interacting with us and try to assume that they are operating on that good faith basis. That's what we're going to do. I want to have more positivity out there in the world. Lawyers are very often and often correctly complained about for being those that bring the parade of horribles, that think about all the many, many different ways things can go wrong, things can go badly. And at the end of the day, what I want to do is I want to talk about what the law says. Sometimes we editorialize, sometimes we advocate for change and reform to the law, but very often I'm trying to describe why you are seeing story X in the news. I go back to last summer when we talked about Spider-Man being bounced between Disney and Sony and looking at that situation saying, I know what's happening here. I can offer insight, and doing a video series on that. And there were people in those videos. You can go to those comments from last summer. You can look at those and you can see people calling me an idiot and picking Sony's side or being a Disney shill. And again, once again, I like it when both sides think I'm a shill or a problem for the other side. That always means we're hitting a good middle ground there. But, we predicted what was going to happen with respect to that almost entirely correctly, including the time frame that it would happen on. And so hopefully the people that made those comments remember what they commented on, remember that video and say, yeah, okay, that actually was insight. That was understanding of the negotiation process, how corporations think and operate. And maybe it's not evil. Maybe it's bureaucracy. Maybe it's the way the law works. Maybe it's the way the corporate paradigm works in and of itself. And that's how we arrive at news item X or news item Y. And if I can give that insight, I'd like to try to be able to. So yeah, I certainly appreciate the comments of, there being bad actors out there. There being people that aren't going to listen. But, I think Ross in particular, was willing to talk to me for 2 hours, was willing to actually watch my video. And while maybe some of the stuff bounced off him, I think at the end of the day, he got a little bit more insight. I think if you look at that Accursed Farm stuff, you see circumstances where he said, hey, a lot of lawyers told me I was wrong on this. And I think that's kind of the first step to understanding. And I'd like to think I was a part of that. And I'd like to think that was helpful. So I guess that's been Virtual Legality Live for today. The first time we scheduled one of these a couple days in advance. Thank you for the people that have joined us, for checked it out. This will be archived. I'll figure out exactly where to archive it, but it will certainly be in kind of the uploads videos section of the channel. I appreciate all the people that have come in, that have chatted, that have commented, that have questioned, the people that have given super chats. I appreciate it all. I'm sorry about the lags. We'll see if we can correct that. Right now it's telling me it's an excellent connection. I don't know that anything has really necessarily changed at my house, so it might be a YouTube side of things. And we will certainly look at alternatives for what works and what doesn't. But an hour and 15 minutes later, it appears to have worked mostly all right. So thanks again for everybody joining me, and I will catch you on the very next episode of Virtual Legality.